Hello, everyone. My name is Frank Angelari. I'm the president of Brooks Cushman, and we want to welcome everyone on the phone to our webinar. During today's discussion, Chanel Carswell and I will be reviewing 6 decisions from the U.S. Supreme Court in the 2018-2019 season, and these are all, of course, intellectual property decisions. There are 2 patent, 2 trademark, and 2 copyright. If you have any questions, please type them in the chat box, and we will try to answer them if possible. And once we're done with this and in days following, a recording of this webinar will be available on Brooks Cushman's website in the Media Center. So we will now get started. As I mentioned, my name is Frank Angelari. I have been practicing intellectual property law for over 25 years, and I focused my practice on litigation and post-grant proceedings. With me today is my colleague, Chanel Carswell. She is the co-chair of our litigation practice. She has litigated cases across the country in areas of trademark, trade dress, copyright, and patents, as well as those matters in a wide range of industries. Okay, so now we can get forward with our presentation. As mentioned, we've got 6 Supreme Court cases, all from this recent season, and it just so happens that 2 are patent, 2 are copyright, and 2 are trademark. Chanel and I will divide them up. I'll take the patent cases, Chanel will take the copyright cases, and we will split the trademark cases. The first case we want to talk about is a patent case, and it involves the on-sale bar, and that is the Helsin case. The specific issue in this case was essentially whether confidential sales count. The issue is stated up there whether under the AIA an inventor's sale of an invention to a third party that's obligated to keep it confidential qualifies as prior art for purposes of determining the patentability of the invention. And the answer is yes. This case, as we'll get to in a second, this issue was triggered by the amendment in the AIA that in some respects linked on sale with public disclosure, but the Supreme Court held that an on sale that's confidential can still be prior art under the on sale bar. So let's look at how they got there. Okay, background of the case. Helsin is the patent owner. They had entered into 2 confidential agreements, one of which was an agreement to supply the patented drug. The agreements were announced in a press release, but the actual underlying technology was not. 2 years after they entered into those agreements, they filed a patent application, and of course that issued as a patent, and then the defendant challenged the patent under the on-sale bar based on those confidential sales agreements. The district court actually held that the AIA changed the law and held there was no on-sale bar, but the Federal Circuit reversed. Which brings us to the Supreme Court. We have a unanimous decision from the Supreme Court, which is reasonably common in IP cases, and one of the reasons at the beginning of each case we note that just because they tend to be more uniform, although there are some exceptions. We'll talk about that today. Toward the bottom of the slide, you'll see the language that everyone relies upon. Section 102A1 is quoted in the last 4 lines. It says, a person shall be entitled to a patent unless the claimed invention was in public use, on sale, or otherwise available to the public. Okay, so that otherwise available was the language that was new in the AIA, and it led many to believe that an on sale needed to be available to the public in order to trigger the bar, and the Supreme Court said that it did not. And here's why. They basically said that everybody's known the law for a long time, including Congress, and if Congress had wanted to change it, they would have been very clear. The third bullet point on this slide 8 says, in light of this settled pre-AIA precedent on the meaning of on sale, we presume that when Congress reenacted the same language in the AIA, it adopted the earlier judicial construction of that phrase. So since on sale was so well known, and they used those exact same terms, the Supreme Court basically said that they were going to presume Congress didn't mean to change it, and therefore no public requirement to the on-sale bar. So that's the Helsin case, and that's the first patent case. The next 2 cases are copyright, and Chanel's going to take those.
Good afternoon. This is Chanel Carswell. The first case I'll talk about relates to the limitations on recovery of costs in litigation. In Rimini Street, Inc. versus Oracle USA, Inc., the question was whether courts have the discretion to award a prevailing party costs under the federal general cost statute beyond the type of cost the statutes expressly allow. The court unanimously said no. Absent express authority, courts may not award litigation expenses that aren't specified in 28 U.S.C. 1821 and 1920. The background of this case. Here, the jury found that, in Oracle's favor, finding that Remini had infringed various Oracle copyrights for computer software. Oracle was very, very successful, earning a whopping $50 million in damages, plus the district court granted them $33 million total in fees and costs, which was reduced just a bit, down to 31.9 on appeal. The district court was also feeling particularly generous and gave Oracle an extra bonus, another $12.8 million for litigation expenses that included expert witness costs, e-discovery, and jury consulting. The problem with the award is that the federal cost statutes are very specific about the types of costs that can be recovered. None that were included in the district court's award make the cut. As you can see here, Section 1920 lists 6 very specific categories, and it covers things like court fees, transcripts, witness mileage disbursement, those types of things. And 1821 also sets reimbursement rates for per diem and mileage expenses. The Ninth Circuit, however, is never afraid to blaze a trail, and relying on its own precedent, said that its affirmance of the award was justified based on its expansive interpretation of the term full costs in Section 505 of the Copyright Act. According to the court, that term includes the litigation costs it awarded, despite the fact that the court acknowledged that those costs fell outside the scope of the categories delineated in 1920 and 1821. It's not clear what the boundaries of available costs would be under the Ninth Circuit's interpretation of Section 505, in fact. Presumably, the Ninth Circuit considered that a question for another day, but the Court of Appeals rejected the Ninth Circuit's view unanimously and reversed the $12.8 million cost award. The court held that a statute awarding costs will not be construed as authorizing an award of litigation expenses beyond the categories in 1821 and 1920 unless there is an explicit statutory instruction to that effect. The court, to get to this decision, it looked at other statutes that expressly expand the scope of costs beyond 1820 and 1921 to demonstrate that when Congress wants to allow a broader scope of costs, it knows how to do so, and it does it expressly. The court also looked at its own precedent, a prior case which held that I believe it was witness fees were outside the scope, certain witness fees were outside the scope of 1920 and 1821, and they weren't allowed. In a somewhat snarky rebuke of Oracle's proposed interpretation of full, Judge Kavanaugh said that courts should apply the same construction of full that applies in common phrases, and the examples he cited were that a full moon means the moon, not Mars. A full breakfast means breakfast, not lunch. In short, full, according to the court, just means all costs available at law. The next case I'll talk about has to do with the pre-suit registration requirement, and that case was Fourth Estate Public Benefit Corp. Versus Wall Street. The question there was, before filing a copyright infringement suit, is it enough for the claimant to have filed an application, or must the claimant's application have been examined and either registered or denied? The court said the latter. The application must have been examined and either registered or denied. The court affirmed the 11th Circuit 9-0, Judge Ginsburg authoring the opinion. The background here, Fourth Estate is a news organization, and it filed a copyright suit against Wall Street. The license agreement between the parties required Wall Street to remove all content produced by Fourth Estate before it canceled the agreement. Wall Street did cancel the agreement, but continued to display articles produced by Fourth Estate on the Wall Street website. Fourth Estate then filed a copyright registration for the infringed articles, and before those applications or that single application was processed, Fourth Estate filed suit. Wall Street then moved to dismiss, arguing that the pre-filing precondition of registration had not been met. The district court granted Wall Street's motion, and the 11th Circuit affirmed. Incidentally, Fourth Estate's app was later refused registration for the articles that they alleged were infringed. This case raises an issue that the circuits have been split over, specifically whether just filing an application satisfies the pre-filing prerequisite for a copyright infringement suit. The dispute arises from interpretation of Section 411A of the Copyright Act, which is shown up in part on this slide. The plain language of the first section of 411A says that registration is a precondition for filing suit, but the Act doesn't then go on to define what registration means. The next sentence, however, has been interpreted to mean that a claimant alternately satisfies its pre-filing obligation when it makes a deposit, files the application, and pays the fee. This slide summarizes the split. The 10th and 11th Circuits apply the registration approach, requiring either registration or denial of an application. The 5th and 9th Circuits follow the application approach. The Supreme Court accepted cert to resolve this split. It adopted the registration approach for a host of reasons grounded in the copyright statute, specifically provisions it found inconsistent with the application approach and general principles of statutory construction, including the fact that the application approach ignores the end of the second sentence in 411A. The second sentence requires deposit, an application, and payment of fees to have been delivered to the Copyright Register, but then it goes on to say, and registration has been refused. This language suggests that the application had to have been processed, otherwise this language loses any meaning. Justice Ginsburg also noted that the last sentence in 411A allows the Copyright Register to join a copyright infringement suit as party on the issue of registrability of a work. Under the application approach, this language would be negated because it would preclude the Copyright Register from participating if the suit is filed before the application is even processed. So that covers the two copyright cases. I'll turn it over now to Frank to take on the next patent case.
Okay, the second patent case from the Supreme Court this term was who can file an AIA proceeding, so like an inter partes review or a CBM or something like that under the new proceedings under the AIA. The issue specifically is whether a federal agency is a person who may petition to institute these kind of proceedings under the AIA, and the Supreme Court held no. We hold that a federal agency is not a person who may petition for post-issuance review under the AIA. This was, they reversed the Federal Circuit in this case. The Federal Circuit went up there twice this year, and they were 2-1. This was their loss. Here's the background. Return Mail sued the Postal Service in the Court of Federal Claims. The Postal Service filed a petition for CBM review under the AIA. The Patent Trial and Appeal Board ruled that the patent was ineligible and canceled the claims, and the Federal Circuit affirmed. Judge Sotomayor wrote the opinion, the majority 7-2, and interestingly enough, the question of whether the federal agency is a person that can bring the action, as you can imagine, the patent statutes didn't define the term, otherwise they wouldn't be here. So this case, in a sense, went off on a general presumption, and that's stated here in the second bullet point. In the absence of an express statutory definition, the court applies the long-standing interpretive presumption that a person does not include the sovereign and thus excludes a federal agency like the Postal Service. The court indicated this presumption reflects common usage and also something called the Dictionary Act, which may not come up very often in folks' practice, but it provides that the definition of a person is used in determining the meaning in an act of Congress. You look at the presumption unless the context is otherwise, 35 U.S.C. or 1 U.S.C. 1. Okay. The Postal Service made 3 arguments why it should be allowed to file, and the Supreme Court rejected all three. These are the three rejections. The first was they made an argument that the AIA uses person in various contexts to clearly refer to the government, but the Supreme Court said that, unfortunately, it's not consistent. Here, the Patent Act and the AIA refer to persons 18 different times, but there's no clear trend to justify an exception. The second argument that the Postal Service made was that federal agencies have been involved for a long time in the patent process, and therefore they should be a person sort of for the whole process. The Supreme Court rejected that because, again, this presumption, unless it's clear to the contrary, presumption of that the federal agency is not a person. The third was an argument in sense from equity saying, hey, we can get sued in court for patent infringement, so we should therefore be able to raise all the substantive and procedural tools that any defendant can raise, and the Supreme Court again rejected that argument, saying just because you're subject to civil liability doesn't mean you can file an AIA proceeding because you have a right to raise invalidity under Section 282 in a legal action, so you're not without a remedy. And then the next slide, I think, is in some respects the most interesting, because it says, finally, excluding federal agencies from the AIA review proceedings avoids the awkward situation that might result from forcing a civilian patent owner, such as return mail, to defend the patentability of her invention in an adversarial adjudicatory proceeding initiated by one federal agency, such as the Post Office, and overseen by a different federal agency, the Patent Office. So I think this is an interesting practical reason to affirm the presumption, which is that it's sort of odd that the Patent Office, one agency, issues a patent and then defends that patent, and another agency's trying to challenge the validity of the patent. It just seems like the Supreme Court called it awkward, and this was kind of thrown in at the end of the opinion, but it seems to me to have a fair amount of significant practical weight. In any event, as I said earlier, they went with the presumption, so federal agencies cannot file AIA proceedings. Now we're going to turn to trademarks.
The next case that I'll talk about, I found it fairly interesting. It has to do with the effect of bankruptcy filings on trademark licenses. The case is Mission Product Holdings versus Tempnology, LLC. The question there was whether a bankruptcy rule that releases a debtor from its obligation to perform under a trademark license agreement also extinguishes the licensee's remaining rights to use the trademarks licensed under the agreement per the terms of the contract. In an 8-1 decision authored by Justice Kagan, the court said no. The bankruptcy rule releasing a debtor from its obligation to perform under a trademark license contract does not extinguish the right of the licensee to continue using the mark under the terms of the contract if those rights would survive under non-bankruptcy laws. In this case, the parties had a trademark agreement that allowed Mission Product, among other things, to use Tempnology's trademarks relating to certain athletic apparel. Before the term of the agreement expired, Tempnology filed bankruptcy, and under 365A of the Bankruptcy Code, Tempnology sought to, quote, reject the license agreement with Mission Products. This rule that it tried to invoke is called the business judgment rule, which allows a debtor to decide if the contract is a good deal for the estate. If the debtor believes it is, he or she assumes the contract and continues to perform. If the debtor doesn't believe that it is, he or she can repudiate the contract with no further obligations to perform. The Bankruptcy Code generally defers to the debtor's choice on this point. Tempnology interpreted Section 365A, interpreted reject, the term reject in 365A to mean that it rescinded all of the remaining rights Mission Products had in the trademark agreement. Quite naturally, Mission Products objected and attempted to invoke Section 365 sub N, which lists several types of intellectual property contracts for which the licensee retains its rights even if a contract is rejected under 365A. The bankruptcy court rejected Mission Products' argument, and the reason it did so, it cited, was the fact that although a number of intellectual property rights are listed specifically in 365 sub N, trademarks is excluded. So the negative inference was that if the Congress intended to cover trademark license agreement, it would have said so. So Bankruptcy Court adopted Technology's interpretation of rejection to equal rescission of the contract and to extinguishment of MP's rights, further rights under the contract to use the trademark. Following the Seventh Circuit, however, the Bankruptcy Appellate Panel reversed the Bankruptcy Court, holding that rejection equals a breach of contract, which is what 365 sub G actually states, not a rescission of license rights. Under 365G, a rejection by a debtor constitutes a breach of contract, and then the consequences that flow from a breach of contract are what go into effect. The First Circuit then reversed the Bankruptcy Appellate Panel, adopting the view of the Fourth Circuit, adopting the view that rejection does equal rescission, the approach held in the Bankruptcy Court, and it followed the Fourth Circuit in Lubrizol versus Richmond, where the court held that a licensee whose contract has been rejected only has a damages remedy, is not entitled to specific performance. The First Circuit, in following the Fourth, reasoned that the Seventh Circuit's rejection equals breach approach created a situation where a debtor has to choose between the risk of losing rights in its trademarks by failing to continue monitoring the mark and the goods associated with it, or essentially naked licensing claims, or continuing to bear the burdens under the contract that the bankruptcy is supposed to relieve the debtor of. Before the Supreme Court, Mission Products advocated for the rejection equals breach approach, and Technology advocated for the rejection equals rescission approach, employing the Fourth Circuit's rationale. Mission Products argue that 365G describes the rejection as a breach and that it should be treated the way a breach would be treated under relevant state or other laws if the parties weren't in bankruptcy court. Michigan Products cited property leases as an example. A lease becomes the property of the bankruptcy estate subject to the tenant's leasehold interest. The debtor cannot simply oust the tenant before the end of the lease. So under that analogy, the same should be true with respect to trademark licensing rights of the licensee. The Supreme Court agreed with the rejection equals breach approach. The court reasoned that there is no reason, Judge Kagan, in an 8-1 decision, reasoned that there is no reason to interpret the term breach any differently in the bankruptcy context. She pointed out that outside of bankruptcy, the breaching party cannot unilaterally extinguish a counterparty's rights. One example that she gave that kind of illustrates the point is if a law firm leases a copier that includes a monthly service agreement, and the dealer then decides to stop servicing the copier, thereby breaching the agreement, it is then up to the law firm to decide whether to keep the copier, continue paying, and sue for damages, or cancel the contract and sue for damages. The dealer cannot, based on its own breach, terminate and repossess the copier before the contract term expires. So basically what the court held is that the debtor is not entitled to more rights in the context of bankruptcy than it would have had outside the context of bankruptcy. A couple of points to note: the court was very clear that this holding applies to any executory contract, not just trademark licenses. The court was explicit in a broad language, so this extends beyond trademark licenses. And in Justice Sotomayor's concurrence, she pointed out that the court didn't decide that rights retained in all trademark licenses necessarily survive a debtor's rejection. Only those where the rights would have survived under non-bankruptcy law, which is usually dictated by state court contract laws. So that brings us to the last case. And Frank will take over for the last trademark case.
Okay, the last case deals with the interplay between trademark registration and the First Amendment, Iancu v. Brunetti. So the Section 2 of the Lanham Act provides that the office can refuse registration if it, quote, consists of or comprises immoral or scandalous matter. And the Supreme Court looked at the question of whether that prohibition is facially invalid because it violates the free speech clause of the First Amendment. The Supreme Court held 6-3 that yes, it is invalid because it's viewpoint-based. In a prior case, the Tam case, they had held that if a trademark registration bar is viewpoint-based, it's unconstitutional, and they held that the immoral or scandalous bar is viewpoint-based. In this case, they affirmed the Federal Circuit 6-3. I think it's interesting that of the 6 cases we've shared with you today, the 2 that were 6-3 were really about non-intellectual property issues in a sense. This one, of course, has the First Amendment, which is going to trigger a lot more, perhaps, different views maybe from the justices. It's probably an issue they've thought about quite a bit. And likewise, the return mail was 6-3, and that deals with whether a federal agency is a person and notions of standing and that sort of thing. Otherwise, the Supreme Court has been unanimous or near unanimous, as is their kind of tendency in IP cases. Okay, the specifics of this case, by the way, this case was 6-3. It had 3 separate dissents and then also a concurrence. If you like the First Amendment, they're good reads. So now, the market issue here, I will spell and not pronounce. It is spelled F-U-C-T. The Patent and Trademark Office rejected this under Section 2, and the Federal Circuit, based on the Tam case, held that that restriction is in fact unconstitutional. So the Patent and Trademark Office appealed to the Supreme Court. Justice Kagan wrote the opinion for the court, and she stated that she summarized the prior Tam decision from a couple of years ago. I don't remember the year, but anyway, that case held that if a trademark registration is viewpoint-based, it's unconstitutional. In that case, the disparagement bar was viewpoint-based and held unconstitutional. That was Tam, and then in this case, at least 6 of the justices felt that the immoral or scandalous mark clause was viewpoint-based, and therefore, for the reason Tam, it's unconstitutional. Now, interestingly, here are some of the examples that the majority cited to prove that this prohibition is viewpoint-based. On the left, you have some of the registrations that were rejected, and on the right, you have some of the registrations that were registered. And the court used these as examples to prove its point that this immoral or scandalous bar is viewpoint-based. So, for example, on the left, you can't spell healthcare without THC. That was rejected. But a different statement against drugs, say no to drugs, reality is the best trip in life, was allowable. They cited bong hits for Jesus as being rejected, praise the Lord as being registered, Al-Qaeda rejected, but War on Terror Memorial registered. So, Supreme Court struck down the immoral or scandalous bar. That brings us to the end of our regularly scheduled points. There are 2 questions in the hopper, and the first one looks like it's for Chanel.
Yes, I will. It appears to relate to the Fourth Estate versus Wall Street case, and I'll paraphrase it. The question is, did the court address the real possibility that copyright owners may lose rights due to delays by the Copyright Office in deciding whether to register? And the answer is yes, although the court was not particularly sympathetic to that issue. The court, in fact, said they believe that the dangers claimed are overstated and pointed out that there's a 3-year statute of limitations for copyright infringement claims. According to the court, the current average time to process a copyright application is 7 months, and you can have an expedited review for a fee. So what was unspoken by the court, essentially, was that if a claimant acts diligently, there is ample time to apply for a copyright and have it examined before you file. The court also said at the very end of the opinion was that delays are a matter for Congress, dictated by budgetary constraints and other concerns, but it was a matter for Congress to resolve and not the court. The court said that the fact of delays is not a reason for it to revise the statutory language. So the court acknowledged the problem, or the potential problem, but it wasn't particularly impressed with that as a reason to construe the statute more broadly.
The second question is about the Brunetti case. which is the immoral or scandalous prohibition. And the question is, paraphrasing, what were the dissents? Why was there an argument about First Amendment, essentially? And the answer is, so they were essentially unanimous on the immoral part of the immoral or scandalous. Everybody agreed that was clearly a First Amendment problem. But 3 justices felt that the scandalous clause could be narrowed in a way that would preserve its constitutionality, narrowed to essentially something along the lines of vulgar and obscene. And Justice Sotomayor, I think, has an interesting point that she makes, which is that people can try to register truly vulgar, profane and words and images, and the trademark office would have things that, in other words, there would not be a First Amendment argument for, but because the court struck down the entire provision, the trademark office would be powerless to oppose it. So I think the dissents really are interesting reads. Everybody loves the First Amendment, and it's worth taking a look.
We have one more question, and I'll read it. In the technology case, would the result in the case have been different if the license agreement related to patents instead of trademarks? And I believe the answer is yes. Section 365N lists specific types of IP for which the licensee retains its rights under the contract, even if it's rejected. So, and one of the types of IPs specifically listed are patent licenses. Justice Kagan, let me make sure I have the right justice here. Justice Kagan discussed that a bit in the opinion when she pointed out the fact that the exceptions in 365N essentially came about as a reaction every time a party attempted to limit the rights of a licensee. So to the extent the issue arose with respect to patent licenses and the licensee was negatively impacted, Congress responded by adding an exception, and these exceptions were subject specific. So if this involves patents rather than trademarks, then this case wouldn't have gone this far. The reason that it did is because trademarks was not amongst the ones specifically listed. So
it would have been the same result, but they wouldn't have needed litigation because it's right in the statute.
Exactly.
All right, I think that exhausts the questions. It looks like we've finished early, but for me, that's always a goal if you can do it. Everybody's got busy schedules. So we will thank you all again for listening. Again, the webinar will be made available for you to view on the firm's media center in the coming days. And feel free to contact Chanel or me if you have any questions. Thank you again. We look forward to hosting another webinar with you soon.